Welcome back to HDtv Health District Television. Often when we think of people living in deplorable, unsafe, and uninhabitable apartments, the next thought most of us have is to call the health department and have the problem fixed. Infestations, broken plumbing, uncaring and often absent landlords just make a call to the health district and make it right. But oftentimes it's not that simple. It comes down to tenants knowing their rights and those trying to help them knowing the right people.
You want to be able to go out there and actually make everything better right away. You go out there, you find a situation, and you want the people who are there to have the best possible outcome as quickly as possible, and sometimes you just can't do it.
Dan Slater works in the Health District's Environmental Health Division and can relate more than his share of tenant-landlord horror stories. He and his colleagues are dedicated to protecting Clark County residents from unhealthy environments, many at the hands of unscrupulous landlords. But he faces jurisdictional limitations and the public's misunderstanding of the Health District's role.
The problem we have is that the Southern Nevada Health District does not regulate apartments per se. Okay, apartments are regulated under a section of the Nevada Revised Statutes called NRS 118A. That's the landlord-tenant agreement. And what that does is this particular law outlines the rights and obligations of the tenant, it outlines the rights and obligations of the landlord, and details all of the remedies if either of the parties are failing to live up to their end of the bargain.
Slater is adamant the best way to help all agencies, not just the Health District, protect tenants is for those tenants to arm themselves with basic knowledge of the law, their rights, their responsibilities, and how to make the system work for them.
The thing I'd really want to stress is if you're living in an apartment, it is absolutely vital you get a hold of a copy of NRS 118A, sit down and read it. You can go to the library, you can download it there, you can go to Nevada Legal Services, they can help you out. You can go to the internet, just type in the letters NRS 118-A into an internet search engine, it will pop right up. Print off a copy, it's about 20 pages long, sit down and read it. It is absolutely essential that you know your rights if you're going to rent anywhere in Clark County.
If essential services to an apartment are interrupted through no fault of the tenant can take action.
A tenant can actually file a verified complaint, and we have forms that tenants can fill out on their own. It's actually a fairly simple procedure. You get a hearing within 3 days of filing the verified complaint. You do have to serve it on your landlord, so you do need a friend or a party not interested in the lawsuit to serve your landlord with a copy of the complaint. But you can get a hearing fairly quickly.
For issues not considered essential services, but which still pose a threat to sanitation, health, safety, and are not caused by the tenant, there's another way to go.
We can help with that, but there are some things the tenant needs to get done before we get involved with it. Under the Nevada Revised Statutes, the tenant is required to give a 14-day notice for any type of problem they're having with that. So if I get involved with coming out to your property and you haven't given the notice, I'm going to have to give the landlord more time to take care of the problem. When you're dealing with any kind of civil matter, it's absolutely vital that the tenants have really good documentation on everything they're doing. They need to document everything that's a problem in the 14-day letter. They need to make sure it's delivered appropriately. They need to keep copies or notes on who did they speak with, when did they speak with this person. Because if this goes to court, the judge is going to be asking all of these questions. And the better prepared you are when you go in there, the better your chances of prevailing in the court case.
Documentation. So you always want to have proof. We would advise tenants to send it certified. Write out a letter, dear landlord, my unit, the air conditioning in my unit isn't working. I need you to come out and fix it. You have 14 days to do so. Now, there are certain things that need to be in that letter. One is give them the time frame. I want you to fix it within 14 days, or you can terminate the lease agreement if the landlord doesn't fix it. You can also withhold rent if you escrow that rent with the court. Now, of course, there are some nuances to withholding rent, but you need to notify your landlord what you intend to do if the landlord doesn't fix. And some of the things you can do is terminate the agreement and move out. And the landlord has to give you back your security deposit and any prepaid rent. You can notify your landlord that you intend to repair the problem yourself and then deduct it from your rent, but you can only do that if the cost of repair is less than 1 month's rental amount. Or you can withhold rent, and you have to advise your landlord that you're withholding rent. Send that notice to your landlord, keep a copy for yourself, make sure you date and sign it, and then send that notice to your landlord. I would advise that you get some proof that you sent it, either delivery confirmation, signature confirmation, or send it certified so that you have a record that the landlord received the notice. And then wait the prescribed time frame. If the landlord doesn't fix, then you can do what you told the landlord you were going to do in the letter.
A word of caution here. Withholding rent is a process tenants really need to understand. It's more than just deciding not to pay the landlord. So is eviction of tenants who voice justified complaints. And while it's all spelled out in NRS 118A, we strongly suggest you speak with someone at Nevada Legal Services or the Neighborhood Justice Center and learn what your rights and responsibilities are. The opinions shared in this story by Ms. Gherkin are meant to assist your understanding, but not as legal advice.
If you've given the 14-day letter and they have not done anything, yes, the health district can come out. We will send an inspector out to the property. We will investigate and document what we see out there. We will meet with the landlord, and we will try to do our best. We will do our best to get the problem taken care of.
We absolutely advise communication, but at some point it's going to become kind of like it doesn't matter anymore. And at that point in time, we'll often advise the tenants to contact the health district, because oftentimes threats from government agencies can spur some landlords to correct problems.
The intervention of a government agency or a judge's finding at a verified complaint hearing often is enough to get landlords to comply. Very few of these cases actually ever proceed to expensive and overcrowded courts. So, armed with knowledge as tenants, don't be afraid to stand up for your rights.
So I'm not really sure if I know of many tenants that have actually filed lawsuits against the landlords. The easiest thing for the tenant to do is to file that verified complaint. And regarding the verified complaints, I do think tenants can win. If they can show that the landlord was notified, they have pictures showing the condition of the apartment, or that the air conditioning unit isn't working, if they can show all of these things, then yes, then I think it's a high likelihood that the judge will make the landlord fix the problem.